Morning, everyone. Thank you very much. Can we get together and start and not be like Indian people and start on time? Hello and welcome, everyone. First and foremost, I bring you warm greetings from the board of SARIPA, our Chief Operating Officer, Renee Becker, who's here with us. It's unbelievable that it's the first time I've seen her in person for over 2 years. And the wonderful and hardworking Angela and Vida, who constitute the engine room of SARIPA. It's my great honor and pleasure to welcome you all today. It's just simply awesome to be back, to see everybody laughing, engaging, talking. I think that's what life is about. And I think that's what we want to embrace going forward in various different forms. Of course, I'm delighted to be present here with you in this beautiful location with a great view over Johannesburg, and of course, a far cry from the state of our roads and the state of our traffic lights. And of course, you're fortunate enough, the 80 of you, you've got electricity today. So you should be grateful at the fact that you're living in the world. This is the second Northern Region conference. And of course, they've taken the lead in the regional conferences. And we have a few distinguished guests and panelists with us today. I thank the panelists for accepting the invitation to participate in today's conference. And of course, thank you to all of you for making your time to come today to this conference. These events are important in our calendar, and SARIPA will embrace the new post-COVID world, and where possible, have hybrid events. I can tell you that internationally, and it seems also very much locally when we engage with events organizers and coordinators, there's a rush to have in-person conferences. And I think it's one thing in this world that will not change. It's this togetherness and this being together and just seeing faces of our friends and our colleagues. Today's conference is being attended by over 80 delegates, and I'm told over 30 to 40, if not more, people who have registered online. I, for one, am really looking forward to my first post-COVID in-person event, and I hope that my nervousness and anxiety doesn't rub off on you guys, because it is difficult to see and engage with the human species after 2 years. I want to thank members of the Northern Region. Its chairperson, Colin Strime. I'm not sure what happened, but just before I fell ill with COVID about 3 weeks ago, there was this gush of wind that ran past me as my wife and I were strolling in our suburb. And I thought it was a bird. No, it wasn't a bird. Was it a plane? No, it wasn't a plane. Was it John T. Rhodes? No, it wasn't John T. Rhodes. It was Colin Strime, all strapped up and running as fast as he can past me. And of course, I want to thank Buhle, the Vice Chairperson of the Northern Region, Monica Cowan, Ralph Lachman is here today with us, Angie Poole's here with us today, Corne van Staden is also here, for all their valuable time spent in organizing today's event. There's a lot of time that goes into events like this, and I'm sure you all appreciate it. I, for one, gave INSOL a miss, no comparison. This is a far better event to attend and to be with you rather than to be with some of our European colleagues, boring as they so often are. I think if there was only one thing that would have got me to London for INSOL, it would have been to watch Elton John, just to give away my age, who's performing, I think, this weekend in Hyde Park. I'm sure you'll all be inspired and motivated by today's presentation and discussion. So enjoy what the Northern Region has put together. I think it's brilliant. It's just set the level at a new high. And I'm sure others will also do so. But of course, my thanks from the board, the COO of SARIPA, Renee, to our sponsors, Asset Auctions, Broll, Michael James Organization, WH Auctions, and Hollard Court Bonds for the super venue great breakfast, and I have no doubt an equally great lunch. So thank you to all of you for supporting and being with SARIPA. Before we go to the first presentation and I hand over to Buhle, I just wanted to take some time to present some stats and information about SARIPA. The selling, you know, whenever there's an Indian, there's a sale. So there's a sale now around SARIPA and its milestones and its achievements. I can tell you that we're absolutely delighted at the fact that we've hit the 700 mark members. I'm told, and I think that really deserves around. I think when I started, by the way, before my good friend Eric became involved with SARIPA, when I started, I think we were at about 200, 250 members. That must have been about 15 years ago. So I think it bears testimony to the organization, the level to which we have grown, the level of our interaction with our members, and of course, what it is that we provide our members. Of the 709 members, we have 140 BRPs, and we have 271 IPs or insolvency practitioners. So an organization that is growing. I think I said in one or other conference quite optimistically, but I don't think anymore, I'm looking forward to the 1,000 mark. I really am. Just look at what we've done since the door, and excuse the pun, the lights felt like they were switched off with the COVID virus. I saw a joke the other day and I thought we were going to play it, that I think Eskom has taken the LOL quite literally and figuratively. I think young people say it's laugh out loud. People like me say to my wife, lots of love. I think Eskom says lots of load shedding. So with COVID, look what we've achieved. In 2020, we had 14 webinars. 2021, we had 18 webinars. And in 2022, we've had 5 excellent webinars. The other webinar the other day on section 155, we hit a record, over 350 participants in that webinar. Said to you that the Northern Region has already had 2 regional conferences, April, 9J, in June, sorry, and that's an excellent achievement. KwaZulu-Natal had its regional conference the other day, also great participation, great attendance, great topic. Eastern Cape has had a regional conference. They had one in May, and I'm sure you're seeing the absence of Western Cape. Forgive them. The Stormers won last week, so I can understand that they were engaged in a once-off event of winning a trophy. Except that this was an international trophy, so we'll all grace in that great part. And of course, we've got SARIPA 2022, fan court. Please, guys, we're going to have about 200 seats available, possibly going to increase it, I'm not sure, but please rush. This is going to feel like a real reunion, a SARIPA reunion. And life's way too short. We've lost too many of our members in the last few years, and we must try and make every effort to be there in person. There will be 6 CPD points for insolvency practitioners for the conference and 5 CPD points for BRPs at the conference. There's an excellent lineup. I mean, in true Eric style, you start late January and February preparing for a conference. Sometimes I get irritated, but you just have to live with it and you have to go on and, yes, sir, and move on. And we far down the line. We've got a very, very good, able technical committee that we think is going to take over the future of the SARIPA conference. So you'll see less of Eric and myself in the conference. We have lots of other offerings. There's a golf day. There's going to be sip and paint. I'm not sure what that is. There's going to be our awesome cocktail party, and of course the wonderful backdrop of fan court. And let's not forget the Young Bloods breakfast, which I really enjoy, and I feel a little young. So I just want to end off with SARIPA's vision and mission. Okay, so our vision is to listen to our members and please come up with your suggestions. We're not the gospel truth. We don't know everything. come up with your suggestions. There's the voice in Renee. She passes it on to us, and we then consider. Our vision is still to remain and cement SARIPA's position as the most relevant insolvency and restructuring organization in South Africa on the continent. Admittedly, we've got work to do in the continent. We do. We need to grow into the continent. That's going to be the next phase of SARIPA in entrenching and putting its footprint out into the continent. I was rather jealous yesterday seeing some other report from INSOL saying that something was happening in Kenya. I was so jealous that I didn't even look at it, because I felt, why wasn't South Africa there? So guys, we need to catch up, and I think there's some work that needs to be done there. Of course, we have constant interactions with the relevant regulators in our profession. I think Renee runs that very, very well and ably. And that's very, very important that we provide that feedback. We understand the frustrations that insolvency practitioners have, but we're doing our best in order to ensure that we can work through those. We're trying to bring together, and I think this is the key part of SARIPA, high-level educational content and training to all our members across the country. And that's in the form of webinars, seminars, and we want to now start introducing slowly training programs. Of course, some of you will have seen the brand new SARIPA Insol program in insolvency law and practice. That's well on its way, and we're looking at adding a business rescue program too. And I must confess that I've dropped the ball a little bit, but there's also going to be a program to try and bridge the gap of lawyers in particular, and I talk to myself first, the financial gap that we have in understanding financial statements, how to read management accounts, etc. And we're trying to put together that particular course. It should have started mid-year this year, but it will probably start next year. So we need to grow this organization. We can't just be settled in what this organization is all about. Great people, great attendance, great conference. We need to grow with additional things. And in order to grow, we need you. Okay? You guys are the integral part of our growth. So you need to communicate your thoughts and ideas to Renee. You need to come up with ideas, and we have got a blank piece of paper in which we can then produce whatever you want as members for the betterment of the organization. So with that, I want to say thank you again to every one of you for coming, making the time. I've no doubt you'll enjoy this conference, and I want to hand over to Buhle, the Vice Chairperson of the Northern Region. Thank you very much.
Thank you, Haroon. Good morning and welcome. Those of you who don't know me, I'm Buhle Duma. I'm a partner at Flaxmans and the Vice Chair of SARIPA Northern Region. My Jewish name is Baruch. That's what you get when you work for Flaxmans for more than 15 years. They give you a Jewish name, whether you like it or not. And now I'm stuck with it. Hopefully this will be an enjoyable and educational conference for all of you. On behalf of SARIPA, I wish to thank Hollard for kindly sponsoring and allowing us to use their beautiful venue and sponsoring the breakfast and lunch for this conference. How can I forget to thank our government for allowing us not to wear masks anymore? Now we get to see your beautiful faces. Look at you. Isn't it wonderful? Today, to keep you warm and entertained, we have two hot topics and formidable speakers lined up for you. The first topic deals with insolvency. The second topic deals with business rescue. I will now hand over to Lizelle Acker to deal with the insolvency topic, but before I do so, let me introduce her to you. Lizelle is a member of the Johannesburg Bar, but before joining the bar, she was a practicing attorney for 10 years. She specializes in commercial litigation. She has extensive experience in business rescue and insolvency. Lizelle, I hand over to you.
Is it good? Thank you. Good morning, everyone. Firstly, thank you very much to the Northern Region Committee. It's good. Thank you. I said not to make this obvious. Thank you very much for the opportunity to talk today. And yes, it's the first one without wearing masks. I'm embracing it. I might be sorry for it. I hope not, but only time will tell. Haroon said there will be presentations. I hope he didn't mean slides as well. I will not be using a slide. Firstly, because it will only contain legislations and sections and regulations and quotes out of judgments, which is just flippin' boring. And secondly, I just didn't have time. But if you believe me on the first one, the second reason is irrelevant. So the topic today is those poor provisional liquidators. Now, the reason why this is important for me, I think, is one, it relates to the recovery of fees, and fees are important. It goes to the heart of a provisional liquidator's blood, sweat, and tears, time already spent. What now? Secondly, all liquidators, final appointed liquidators, must first be provisional liquidators. And with the way in which the delays in obtaining final orders, delays in convening meetings, first meetings, second meetings, getting resolutions and extension of powers, directives from creditors, it takes a long time before a provisional liquidator can or a liquidator can actually do its job. And then, even then, you might sit with the following scenarios. Either the liquidation order, provisional order gets discharged, and it's over, it's done. Or you, in fact, get, as we call it, voted out. You don't get finally appointed. But a month or two or a year or 2 years has lapsed, and you've done work. The third thing why this is an important topic for me is there are consequences to the discharge. And there's consequences for you as a provisional liquidator, even after, and there's this concept of some duties remaining on you, but there's no liquidation anymore. You remain a provisional liquidator because you still have your certificate, you still have your bond of security. Pollard will want to know what you're going to do about it. What now? And unfortunately, I don't think that I've got all the answers. So I understand that there is some debate in the industry as to what to do with this. Is it illegal? Is there a legal answer? Or is it just a practical solution that we need to look at least in the meantime? I think it's the practical solutions that we need to look at. Now, as I said, we know liquidators are entitled to their fees. Section 384, and that's why I said that would have been the only thing that would have been up on the screen. So, and that's, you all know that in any event. Section 384, read with the regulations and read with the tariff and the schedules, tells you exactly what it is that you are entitled to. Liquidators, you are entitled to that only upon confirmation of an L&D account. That doesn't happen in a provisional order, at the provisional liquidation and liquidators appointed stage. So in the meantime, as I said, you as a provisional liquidator expend time, incur expenses, go on roadshows, recover assets, safeguard assets. All of that takes a lot of time, but mostly a lot of direct, out-of-pocket expenses. Now, one thing is clear, is that you are entitled to something. The regulations to the Act says that where your appointment as a liquidator is provisional, and either there's a dismissal or a withdrawal of the petition, or you don't get finally appointed. This is what it says. You're entitled to a fee to be taxed by the master with due regard to special circumstances. Then there's a little proviso when you cross to the cross-referencing of all the 7 sections, which actually just tells you that you're entitled to a reasonable remuneration. Now, I always understood it that liquidators are just entitled to the percentages that's prescribed by the tariff. Lo and behold, that's not actually so. So, although I'm not here to dictate or proffer that you need to move outside of that, but that's not actually what it says. That's a tariff, that's a guideline. We love to say in the law when you deal with rules of court and you just say it's just a guide. So it's a guide, but you follow it because there's good reason for you to follow it. But when it comes to what is reasonable, the Supreme Court of Appeal says, and I'll read snippets of it. It says that the court described the approach to be adopted by the master in determining whether the remuneration of a provisional liquidator is reasonable is as follows. The master, as a statutory functionary, is not free to choose whether or not to tax the liquidator's remuneration. The master must tax in accordance with the tariff, but having done so, may reduce or increase the amount arrived at by applying the tariff if, in his or her discretion, there is good cause to do so. The dominant provision in section 384 remains that the remuneration to which a liquidator, which the court said includes a provisional liquidator, is entitled to is remuneration for the work or services rendered, not a set commissioned, and that must be reasonable. I want to give you the following scenario. You're a provisional liquidator and you are appointed as such. And you're appointed as such during level 4 or 3 of COVID. It's a big company with lots of assets scattered across the country. Your duty as a provisional liquidator is what? To go and get the assets, ensure that you take control of it. How do you do that? You need to either get the sheriff to assist you, you need to get auctioneers and people that's willing to hold it for you, to safeguard it for you, storage facilities, etc., etc. So you decide to go on a roadshow. To go, in this specific instance, to go and collect trucks. In various regions, you contract with storage companies and houses to store those trucks for you because you have to safeguard it. The petitioning creditor is a large financial institution. On the return date, or before the return date of the provisional winding up order, the company opposes the final winding up. And there's an extension of the rule NISA. In the meantime, the petitioning creditor and the company's directors settle. Part of the settlement is that the winding up order will be discharged. You are the provisional liquidator. You know about it. You know that it's opposed. You just do your job. Your job is to safeguard and to recover the assets in the meantime. You know that there's talks of settlement. It's got nothing to do with you because you put your head down and you work. The petitioning creditor and the company settles. Settlement agreement is made an order of court. One of the terms of the settlement agreement is that the winding up order be just discharged, with no terms attached to it. Order gets granted, a settlement agreement gets made an order of court. Winding up order is discharged. You, as the provisional liquidator, still sitting with the assets, scattered around the country, and you've concluded the agreements with the storage houses. What do you do? But more than that, two things now needs to happen. You as the provisional liquidator has a duty to return the goods. You must return the assets. And not why you have to report an account in terms of the common law to the insolvent company, say what you've done, what you've not done, because in the meantime, you've used perhaps some of their money or some not, or you've done something with some of the assets or not. And you also need to account to the master. Now, this is where the interesting part comes in. There's something called an intromission account. Now, very interestingly, there's one judgment. And the judgment is come what may properties and mega super cement. And I love the come what may because it always, I remember it because come what may will get our fees. It's kind of that's how I remember it, which deals with this concept of an intromission account. The court says literally on the second page, and I mean the first page is literally just the headings. So it's basically the first page. The court says the Companies Act makes no provision for the submission of an intromission account. It would seem as if the submission of this intromission account resulted from some policy document issued by the Master of the High Court in regard to what is to happen after a company has been discharged from liquidation. There's no such thing. But the master is not going to release you. It's not going to reduce your security bond. Hollard is going to knock on your door and ask, what am I going to do about you? Interestingly then enough, in this come what may judgment, the court says the moment that a winding up order is discharged, it says that the and I'll read this to you again, sorry, just a small paragraph out of the judgment, is effectively the winding up order in terms of which you as a provisional liquidator were appointed. That winding up order becomes a dead letter. It's done. Your appointment is in terms of a winding up order. Your fees, duties, everything is determined by Chapter 14. But the company is not in winding up. It's a fully fleshed juristic person, willing, presumably able, and entitled to continue with business as normal. But here you are, as a provisional liquidator, hanging on, because you still have stuff to do and fees to collect. So in this judgment, the court says the argument was, it was years ago, the master actually examined and confirmed intromission accounts. I understand that that's, some masters might still do it, some actually won't. They don't confirm it anymore. And interesting, when I was preparing for this, I found a resolution, and maybe Renee, because she doesn't have much better to do, well, there was a resolution 16 of 2018 that I found from the master's office, where they actually say, and they resolved the master's office, that no intromission account will be considered or examined by the master. But you must still submit it. So, the confirmation, so in come what may, the master still confirmed an intromission account, which was confirmed. And there was a dispute, and there was a dispute about the provisional liquidator's fees, and some of the creditors and the company was unhappy about the fees, which is strange, but I mean, it's once off. The argument for the liquidators was that you can't, there was an attack on the account to open the account, which is strange in itself, but besides the point, to attack those fees so that the fees must be reduced. The argument before the court is because there's no more Chapter 14, you can't attack, review, open an account because there was no account to confirm. The master had no authority to confirm anything. It's not an L&D account. So it's an intromission account, which they've decided through a policy document to have. The court said that the basis on this contention, i.e., that the review application of the confirmation of the intromission account is flawed. The basis of this contention is to be found in the fact that upon discharge of a company from liquidation, the various provisions and regulations dealing with the liquidation process are no longer applicable. It quoted international law, and it said, once an order is stayed or set aside, the court, of course, is not empowered to revoke or recall its order once it has passed and entered. The effect of a perpetual stay or setting aside of an order must mean a virtual end to the winding up process under that order. The statutory provisions that ordinarily would cause certain things to be done no longer apply to the company, and the order for the winding up becomes quite inoperative. Doubtless, the court would protect the interest of the liquidator and any person who could possibly be affected by its order by invoking the latter part of the section, and we have an equivalent section in South Africa, to grant the order for the stay or the setting aside on terms. But once the perpetual stay or setting aside was granted, the winding up process comes to an end. And that's where it concluded to say, but on granting on the stay later on, it says, it renders its own order a dead letter. It then went on to South African law, and it says, Blackman supports the proposition that the statutory provision that ordinarily would have caused certain things to be done no longer apply to the company. It went on, as I said before, and it said, once the order is discharged, the company becomes a fully fledged juristic person again, able to conduct its business in accordance with its articles of association. It then brings me to this. Now that I've told you the bad and the ugly, what is the good? The good is that we all still agree, and the court still agrees, that you are entitled to reasonable remuneration. How do we get to that? In the 1964s, this has already been an issue, and the court said that your fees as a provisional liquidator remains a charge against the property of the estate. Your service was in terms of your appointment, but your appointment was for the company. So your remuneration is a charge against the estate. Paid by who? By the insolvent, who's no longer insolvent because it's now operating. But there's also now the limitation, which I don't think will ever really happen. You can only charge a fee, not in any amount in excess of the value of the property that you returned. So if your fee is more than what you've returned, you are limited to the value of that. Then, if in the meantime, as I said, because your appointment was during COVID and a year or 2 years has lapsed, you're still only provisional, and then you just get either kicked out or the order gets discharged. And in the meantime, you've collected money, collected debtors, there was money in the bank. What must you do? You must account to the insolvent, tell the company what you've done with it. But also, the 1964 cases says, you're entitled to account for a fee as a debit for that what you've collected and done, which is reasonable and which can't be more than what you've returned. Now, also, what you're not allowed to do is you're entitled to a fee, you're entitled to recover it from the company, but you're not allowed to sell assets to recover money. And you also don't have a right to retain or protect or keep aside any money that you might estimate your fee would be. In a recent judgment in the SCA, the liquidators, provisional liquidators, transferred an estimated fee of a very reasonable 20 million to attorney's trust account. Whilst there was an appeal pending against the winding up order. In the meantime, the company rushed to court and they said, no, you liquidators are not entitled to transfer money to retain funds as estimated fees pending your intermission account and confirmation or not confirmation, and what's reasonable or not reasonable, and whether or not it's still applicable or not. You must refund that money. And the court said, absolutely yes. The moment that the order is discharged, every single piece of property, asset, money, everything is the company's, must be returned and restored to the company. So, where are we? Moment that it's you as the provisional liquidator have duties and responsibilities. You must do your job well, because otherwise you're going to get criticized and removed in any event. You expend, and you must expend. You must spend time, you must have out-of-pocket expenses. But the moment that the order is set aside, the order is a dead letter, and you must return the assets. You're not allowed to retain anything for your fees. You must submit an intermission account, and you must hope for the best. But you're entitled to your fee, so don't worry about that part. So, practically, what do we do? Practically, as I referred to in the judgment of come what may, the court referred to whether there's an order, there's a discharge or a stay on terms or not. And for all intents and purposes, until such time as someone hopefully takes on this issue, which is a clear, I think, lacuna, and I think that's why the master also tried with this policy document to introduce this intermission account, because there's this ancillary responsibilities that still lingers upon the discharge, but Chapter 14 doesn't assist us. So what do we do practically? So we must also find a practical solution for what we must do. And that practical solution, I think, lies in section 354 of the Companies Act. 354 says that upon a stay or a discharge, the court may make an order on such terms and conditions as the court may deem fit. So I think the solution, practically, legally, factually, call it what you want, is that when you are appointed as a provisional liquidator, to safeguard yourself, you have a right to be remunerated. You've got that right. You're entitled to it. And I think section 354 gives you your ticket in to say that I'm entitled to my fees, and you, Mr. Court, can make and discharge this order, but on terms. So you go to the company, the petitioning creditor, or the creditors, whoever is now trying to settle. And I see this more often than not recently, and I think for good reason, where petitioning creditors are settling with companies, especially bigger companies where there's, I mean, your fees will it will be more, because there is the uncertainty of when final orders will be granted, how long does it take for the winding up process to take its course, etc., etc. And sometimes just from a commercial perspective, it is in fact, let the company trade, let it continues. You make settlement terms, payment terms, and maybe there's a happy story there. So I do see this happen more often than not. So when you as the provisional liquidator finds out, or I mean, everyone, you always will know this, that there's a return date, you need to make sure that you proactively engage. Are there talks of settlement? You, as the provisional liquidator, will be close to the larger creditors. You will probably know the petitioning creditors. You will know what is happening. If there's an opposition on the return date, you probably know this. So you need to make sure that you know whether or not there are any settlement negotiations. And you can ask. Because if there is, one or two things needs to happen. Either you should agree a fee immediately, or you need to agree on terms, how all of this is going to happen once the order becomes a dead letter. Negotiate terms that you are now, in terms of an agreement and a court order, entitled to retain funds or entitled to do certain things. Be proactive, negotiate, don't be shy, and impose, because if not, 354 is your ticket to court. Because if they don't agree, you intervene. And you say, court, once you discharge this, I'm sitting with trucks in every single province. I've concluded agreements. I need to return this. To return everything to where I found it is going to also cost money. And I'm the one that holds that liability, but on behalf of the company. So we couldn't agree on terms. So I want you, court, to impose terms which you consider appropriate as part of the order for the discharge. And you say what you want so that a court can decide, protect your rights and your interest, and make sure that you actually recover. Because if that ship has sailed, you're sitting, and I've seen many provisional liquidators in recent months that says, I've spent so much time and effort on this already. Let it go. I'm tired now. It's a lesson learned. It's an expensive lesson learned. I'll be better based next time. And you lose out on fees post-COVID, which none of us should be doing. That is, from my side, the practical solution to this. If there's anyone here that has another one, please speak now, or don't hold your peace. You can forever say. But I would like to know from you guys whether you are experiencing this, what your current experience with the master on intramission accounts, what examples or not examples, you don't have to mention names, you have, and whether you've sat in a position where you've been able to either recover or not recover because you've just, for lack of a better word, given up because enough is enough. You're exhausted. Your blood, sweat, and tears is just not worth this anymore. If there is, I would like to know this. Otherwise, I did say to Colin, I'm not going to take the whole hour. It's much better to mingle outside than to be sitting here and listening to me. So, yeah, then yes. No.
person storing those assets hasn't been paid and is entitled surely to hold those and claim a lien over those until his fees and the storage costs and so on have been paid.
So before I answer your question, I just need to say this, that there's a story at the bar that goes like this, which is apparently true. There was a very prominent counsel arguing in the Constitutional Court. He was arguing his heart out. And the next week, he was back in the Constitutional Court. And as we go, you go and introduce yourself to the judges, and then there's all sorts of talks that's happening. And the judges ask him, but Mr. or Mrs. So-and-so, you were here last week arguing exactly the opposite, what you're going to argue now. And he said, Justices, it's easy. Last week, the other party was paying me. So I'll give you the answer. but actually, that is it's a straightforward answer. And I've got Meshkin here, and Meshkin actually gives me the authority for that as well. Provisional liquidator has no lien on the company's books and records or assets for the remuneration due to him. And that's the case, Howard Motors versus Waterson, 1963. The reasoning behind that is apparently this: the same as what an employee or a director is not entitled to retain books and records of a company for its outstanding director's remuneration, etc. That's the argument that that was used in this judgment to say why a liquidator being appointed as the management of the company is not entitled to hold it as a lien.
Thanks, Lizelle.
I'm scared for you.
Given Uncle Philip's question and your answer, and there's no lien, but you said that there was some right that the provisional liquidator would have over the assets. And you spoke about that section that opened the door for the intervention of the provisional liquidator. So would it be possible for the provisional liquidator to intervene and bring some sort of application in those proceedings for discharge and say, I'm unable to reach an agreement in relation to my fees as provisional liquidator, you court must give me some form of security over those assets. Alternatively, you court determine the reasonability of my fees, because there's no other forum in which it can be determined. And here's three views of esteemed and experienced liquidators in the profession who say my fees are reasonable. Because however are we ever going to break this logjam? Because it seems like the liquidators must, exactly as you say, this is school fees and I'm prepared to pay for them.
Yeah. Arun, so the first part of your question, I think that's exactly what needs to be done. You need to be proactive. You go to court and you say, once you've discharged this, I've got nothing. But it can't be. It just cannot be. So I, as the provisional liquidator, have tried to settle and negotiate, and we are unable to do this. I know what the company's financial affairs look like because you're the provisional liquidator. I want to retain X amount, or I want to hold on to that, or I want something as a preservation for that which because law says I'm entitled to a fee, and my fee is a charge against the property of the company. That is what I want. So please, this is what I suggest. This is what I want, because I know this is what the company has got. There's R1 million in the bank account. I want to hold 500,000. I'm going to keep it in trust. The interest is going to run to the benefit of them. Please just help me to protect this. The second part to your question for me is very interesting, and I don't know. The difficulty I have with the court determining a fee is I don't think it can do that. Because although the authority says that there's no such thing as an intromission account, the regulation says once a provisional order or provisional liquidator was appointed, it's entitled to a fee to be taxed by the master with due regard to special circumstances of the case. So a court is presumably going to say, I don't have the jurisdiction. It falls under the jurisdiction of the master and the master alone. You have to now go and stand, and I don't know, it's because it's whatever is reasonable and reasonable in the circumstances, but it's not more than what is the assets that you've returned, and. So I played around with that idea, and I would like to do that. But I've got this question mark that a court is going to tell me you must first go to the master. It's the master's jurisdiction in terms of the regulations, and it must tax you. And then if you're obviously not satisfied because it reduced or whatever, you bring it to me for a review. So the second part I don't think is workable, but the first part, absolutely. And that is what must be done to protect your own interests as a provisional liquidator.
Lizelle, thank you. From a fairness perspective, I have a difficulty to understand or to accept, specifically with regards to your 20 million retention example that you used, where provisional liquidation orders are granted on an ex parte basis. Why the company would then be liable to pay the provisional liquidator? Because the company did not have a say in opposing the granting of the provisional order. And if the provisional order is then discharged at a later stage, why would the company then remain liable to the provisional liquidator for its reasonable fees? And why not the petitioning creditor?
Yeah, so two things. I think ex parte is a bit different. At the moment that an ex parte liquidation order is granted, I think you already have trouble, and presumably the company will anticipate it. If it doesn't, then I mean it's a fair for all, because you had the right to anticipate, you didn't. So the fairness, I think, then you get put back on an equal footing. And that is exactly the reasonableness question, is exactly where my difficulty was as well. And I don't think by mere protecting and recovering of assets is unreasonable at all. I think where the difficulty is going to start coming in to justify reasonableness or not is where extension of powers applications has been pursued. Insolvency inquiries are being pursued. Disposition applications are, well, you probably won't get that but wherever those type of actions and steps are being taken, I think you're going to start getting into some debate as to whether or not it's reasonable or not, because that's exactly what it's going to say. It's going to say, you've expended and you've completely depleted my entire estate. I had 10 million rand in the bank, and today I've got 2 million because you've paid attorneys and you asked for an extension and you held inquiries and you had acting retired judges sitting. And now the order is discharged. So I, as the company, was right. The practical solution to that is still, I think, once you go to court for your extension of your powers or to convene your inquiry, etc., you will presumably deal with the cost aspect of it in any event. So either it would have been dealt with, and it would say then it's cost in the administration. So then you can still say, look, a court before you decided that it is necessary for me to extend my powers. They were satisfied. The court agreed it is necessary for me in the meantime as a provisional liquidator to start with an insolvency inquiry. Who are you as a different court now to say that I was not entitled to do that? So it's going to be a play off against those type of things. And then again, it is persuading a court what is appropriate, what is reasonable for terms so that the court can impose that before it's discharged. Again, the difficulty with those things is that those are out-of-pocket expenses. It's not a fee, it's not a percentage, it's not time spent, that is out-of-pocket expenses. So I think it's fact-dependent. Is certainly a major factor that will be taken into account, I think, when it comes to that. But again, if it was 2-3 years of winding up and an order is only later discharged, there was a, now that Mr. Strime is walking in, he had a matter recently in the Levick estate. Dippenaar said, Dippenaar judge confirmed provisional liquidators are entitled and must fulfill their duties and do whatever they have to during the time of their time in office as provisional liquidators. So you must do that. So if you have to extend powers because you need to reach something that you can't to protect it, you bet your bottom dollar if you're not going to do it and there is a final order and there is a final appointment, you're going to be criticized for not having done that as well. So it is fact dependent, but I think that fact dependent there, you need to weigh all of that, but certainly a factor before you just rush in and do inquiries and do extensions. I see that's the norm now. Before you do that, just apply your mind and see whether there are possibilities of this thing going south. That is my cue. Any other questions? Samantha?
Clarity on Philip's question.
No, I can hear.
Yeah.
No.
Maybe stand up.
We don't have an issue with the loudness of your voice.
Yes, I just want clarity on Philip's question because, as I understood it, he asked whether when there is a third party involved, where if you had to store some assets, and now that party where you stored your assets doesn't want to release the assets upon the discharge of the application, then what is it that you as a liquidator can do?
I think it's slightly different. But so are you saying so the assets that you were safeguarding is with a third party?
Yes.
You now need to return that.
Yes.
But it's not your lien, it's the other, it will be the third party that
Yes.
holds the lien. But I mean, your order is a dead letter. So I think in that case, you will say, look, you are holding someone else's assets. Now it's the company assets, third party and company, you guys are now operating, go and fight it out. If you can't return it, you can't return it. So I don't think, if you can't return it, it's not your asset anymore. It was never your asset, in fact. It was the company's assets. And they need to release it. They can't. Still being done on behalf of the company, although it's you paying it. But if you don't pay it and some third party tries to exercise a lien, it's for the company to then come to the party and say, okay, how do we resolve this? Because I actually need my trucks back. Yeah. Can I be released now, please? Colin.
Not a question, just an observation for liquidators. If you're getting assets returned to the value of your fee, only store the big assets,
Yeah.
the valuable assets. Ignore the small ones.
Keep the small ones. Thank you very much, everyone.
Oh, that was excellent. Well done, Lizelle. Please, guys, let's put them together for Lizelle. It was very captivating. I think this is a convenient time to take a short adjournment for Oh, yeah. Can you hear me? Yes. Okay, we'll take a short or a long adjournment until 11 o'clock. Please use the opportunity to network, enjoy the light breakfast. Thank you. See you shortly. Don't be late. Can you start, please? Thank you. Can you settle down, please? Welcome back. I hope you all enjoyed the light breakfast and networking. Unfortunately, those who are attending virtually missed out on the lovely breakfast. Before I introduce the next session, please don't leave because there'll be a lucky draw and a networking lunch afterwards. So the next session is a panel discussion dealing with business rescue. Colin will be the coordinator of the panel discussion. Colin doesn't need an introduction. Safe to flag that he's the chairperson of the SARIPA Northern Region and joint CEO of Fluxmans. And I'll let Colin introduce his distinguished panel. Colin.
Thank you, Buhle. Welcome to all of you. Thank you for attending, giving up your valuable time, and all of you live on our webinar. Welcome to all of you. We've just had a last-minute change. We were going to have Bongani and Skasana as one of the panel members, but unfortunately, I got a WhatsApp from him yesterday to say that he was at Insol, his laptop was stolen, his passport was stolen, and last I heard he was at the embassy trying to get a temporary passport to get back to South Africa, and he didn't arrive. So apologies for that, but excellent replacement. Thanks to Patlani. He's agreed to sit on as the representative for the business rescue practitioners and to deal with the panel. We've had our session. You may have observed Patlani and I going through a session quickly. So a big, big thank you to Patlani for stepping in for Bongani. It was really a life-saving thing for us. Thank you. All right, so I'd like to tell you that today we're really honored to have SARS participate in this panel discussion. It's a first, it's like a scoop. And a special thanks to Mark Kingan and to the Commissioner Kieswetter for making this happen. It went that high to get his approval, and he sent an excellent top team to represent SARS here today. So we're extremely grateful. Having said that, please, SARS are not here to make policy. They're not here to give you the law. They're not here to interpret the law. We're all here having a mature, high-level, open, frank discussion, and we'd like to keep it that. I know we all have cases, including myself, against SARS, dealing with this very subject. Don't ask questions that you're going to put in affidavits against SARS in the future. If you get an answer from SARS, they are not here for that purpose. They are kindly here to participate. And we would love them to rejoin us at future conferences. We're hoping this is the first of many. So please, let's show them how professional we are as an organization and treat them as colleagues and professionals with whom we interact on a daily basis. And please, no taking advantage of them here. So let's just give them a big hand for being here. Thank you. Right, let me introduce you to the team. First of all, we've got Dr. Tabia. I'm going to give you the SARS team first. So they've sent us a doctor, Dr. Tabia Mabasa, and we're extremely honored to have her here. At SARS, Dr. Mabasa is the business rescue manager in the specialized debt and outstanding returns office. She has experience in business management, revenue management, performance management, managing cross-functional interface issues, project management. She oversees the regional team of SARS business rescue specialists. She ensures that SARS fully participates in business rescue proceedings. She manages business rescue operations and stakeholder engagements in accordance with SARS strategies, objectives in providing taxpayer services. And she's assisted by Edith, who's here, and by Efafu, who's also here. Thank you, Dr. Mabasa, for coming and giving up your time. We sincerely appreciate it. Second on the team is Ashley Dupree, or Shaw. When we had our MS Teams discussions, the name came up as Shaw.
Yeah, it needs to change. It's not going to change.
So Ashley's a legal consultant in the SARS Chief Litigation Office. She's an admitted attorney of the High Court, and she's currently a legal consultant in the recently formed litigation management unit within the Chief Litigation Office at SARS. She deals with specific litigation referrals, but simultaneously handles complex escalations, project management, and reporting within the Office of the Chief Litigation Office. Next is Khalid Buhle, and I must tell you, we're honored to have him here. He flew up from Cape Town, and SARS paid for the AirTech. I'm assuming they paid because we haven't been presented with a voucher yet. So SARS has gone to an expense to actually bring representatives here. So it's really appreciated. Thank you, Khalid, and thank you, SARS. Khalid is also a business rescue operational specialist at SARS in the Specialized Debt and Outstanding Returns Office. Khalid provides advice and support to management and specializes in business rescue matters. His functions include identifying SARS risks associated with business rescues, ensuring compliance with policy and procedures. Khalid also trains specialists on tax-related issues in business rescue matters. He provides opinion on business rescue operational issues and analyzes complex business rescue plans. So all in all, a formidable team. Thank you. Patlani, my good old friend, who I've known for many years, an extremely competent and an extremely good business rescue practitioner. Patlani is a colleague. He has a BA LLB, a BProc LLB, and an LLM in mercantile law. And he's the co-founder and the managing director of Genesis Corporate Solutions. And Patlani has been involved in huge rescues, the South African Airways, South African Express, sorry, not SAA, the South African Express, Afri Oil. He's busy with the Safra Plumbing and Hardware and the Black Mine organization as well. He's busy with it at the moment. And Patlani, thank you, my friend, for stepping in. Sincerely appreciate it. Right. So the first topic that I want to deal with on SARS is the inside track. Let's call it the inside track. We want to know what SARS does as soon as they get notification of a new business rescue proceeding. But we want, as business rescue practitioners, to understand, what do you do? How do you deal with it? How do you approach your systems? What do you do on your systems? And when you interface with the business rescue practitioner, what do you do?
Okay. I'm the manager for the business rescue matters nationally. And we've got a special unit that's called Business Rescue Unit. And we manage it centrally at head office level. So what happens is we've got a dedicated mailbox for the business rescue matters. And that communication has been communicated to the SIPSI. All the business rescue practitioners are aware of the mailbox. And we've also gone to the extent of also publicizing it on the SARS website. And also we have also added there to say, even with the Section 155 compromise, they should be going into that particular mailbox. So we've also strengthened it by putting in an administrator who's on a daily basis managing all the communications that we get from the business rescue practitioners. So we would expect that whenever you get a matter, a company that goes into rescue, that you'd actually contact SARS using that particular mailbox. So upon receipt in our mailbox, the admin person will just alert me And I've got dedicated business rescue specialists across the country who are specifically dealing with business rescue. And now we're actually very fortunate, and I think is a very good time for us to can be able to sit in these forums, because we've sort of strengthened our structure. So in the past, because this business rescue normally resides in debt management division, so you'll find that you've got a lot of matters, normal matters that are not in rescue. So you'll find that the specialist deals with a variety of the cases that we need to collect on. And at the end of the day, there's quite a lot of volumes. And you know that in business rescue, you know how much you promised to give us as a compromise, as compared to other matters that we can chase so that at least we get more revenue. But now we've sort of fine-tuned the structure. Now we've got specialists across the country. I'm sure a lot of you in the forum are aware. You know some of the business rescue specialists that you've been dealing with. So upon receipt, we will allocate your matter to the business rescue specialist. So actually, we used to have specialists, for example, dedicated to the Western Cape. Those that have dealt with the Western Cape matters will be aware they've dealt with Mr. Khalid Buhle. Others have got Edith. Some of you are identifying as one of the specialists that has been dealing with matters in Megawatt Park in Gauteng and so forth. So now we've taken also advantage of the new normal. We can work across the country, and also it assists to actually get an experience or sort of feel of how business rescue practitioners in different regions operate. So they will receive your matter, and upon receipt of that matter, because we're not end-to-end a division unit, so we've got other units that we work with. So we will notify a collector. So most of the time when you get those cases, you'll find that there is a debt already on the book. And we'll have to check if there is a debt and if there is a collector who's currently working, who's intending maybe to enforce, to start with enforcement action. So we'll alert that collector to say, the matter now is in business rescue, so please suspend all enforcement action because now the matter is under the moratorium. And also, we will also inform the business rescue practitioner that your matter now is no longer being handled in a normal process. I am Tabea Mabasa, who is now handling your matter. So all the communication that you are going to be sending to SARS, you must directly send them to me. But we also advise them to send that communication also to our SARS debt management, to the mail address that I was talking about, so that at least we are aware of that matter, and also I'm aware of what's going on in that particular matter. And also, because business rescue is time-driven, we don't want to miss any opportunity of attending the meetings. So what we'll do is, Mr. Khalid Buhle as well is well aware of all the communication. So if, for example, there's a creators meeting that we need to attend, and the business rescue specialist is on leave, so we're able to have sight of that, and we can ask other specialists to attend to the matter. So that's how, at least for us, it's sort of working well in terms of having a dedicated team of business rescue specialists. So what we do now, after having, as a specialist, after having your matter now, I will check now coming to the account. As I said, that some of the matters, I think majority of them, they will have a debt already on the book. So I'll have to look at the debt, and I'm also having to look at whether or not there are outstanding returns. And now you open your eyes. Are you guilty? So there are outstanding returns, and obviously is to let you know as a BRP that there are outstanding returns and need to be filed as in yesterday. And we also will look at whether or not there's a dispute. And from our side, because we work with other departments, we understand that it's a time-driven process. We'll have to look at exactly what's happening on that particular dispute. Is there any other information or whatever that's happening? And if is a matter that can be fast-tracked, we can also liaise with them to say this matter is in this position, and how about you fast-track it and so forth. And also we look at whether or not there is an audit going on, and what is it? Are they still waiting for the company to submit any other information, or where is it in terms of site? Can also expedite the process. And also, if there is any account-related matters like refunds and all sorts of any other issue that is related to your account, we'll contact our account maintenance just to fast track to make sure all this is done in order for us to have the correct claim for SARS. So, and then we'd expect that after that, after having the correct claim, everybody has complied, everybody has done whatever that needs to be done, be it the business social practitioner, be it SARS. We have now a claim, and now we expect that you will let us know when is the first creditors meeting. But prior to that as well, if there are matters that we need to sort out, you know, that door is open where we'll say, this is what account looks like, these are the issues, we need to come and resolve it with us. And then first creditors meeting, we'll get notification as well from that mailbox. And obviously, if the BRP, I see that they will also alert the business rescue, especially that's working on the matter. And after that, we expect that obviously the publication of the business rescue plan. And after that, we'll receive it, and we will, the business rescue specialist will analyze the plan. And while analyzing the plan, and also we have a date when the business rescue, the second creditors meeting is going to occur. And after that, now we need to alert the secretariat that there's this meeting that is coming within these particular days, and can you please organize us a committee, or when is the committee going to be? Can they accommodate us? And then we'll go and present the matter to the committee with the recommendation, obviously with the facts that we would have with regard to the particular plan. And in some instances, you get that Mr. Buhle will, for example, say to you that, you know, because the outstanding matters that, for example, outstanding return, and how else am I supposed to participate now? How else am I supposed to support that this business can be rescued? How are we supposed to see if there is indeed a business in this particular company? And they will literally tell you that it doesn't look good, so I cannot represent you well. I cannot represent you well with the committee. So we try and present the matter, and obviously with also the positive, outlook from the committee. But the committee will consist of a variety of a discipline like legal, finance, and all the expertise will be there. They will now be able to adjudicate, wherein they will give me a mandate to either vote for or to vote against the business rescue plan.
Excellent. I mean, that's so illuminating. Thank you. Fantastic. So you all know how it works at SARS, no?
Yeah, so and also it's very important for us, especially when we're supposed to now take the matter to the committee, the time frames. And that's why sometimes if you ask for an extension, or we ask for an extension because we need to now analyze this business rescue plan, and sometimes it differs on the type of the rescue. And I heard that we deal with the lawyers here, and we'll be talking about the management accounts and all this jargon that they need to understand each other. So that time period, sometimes it can be a bit of, keep us a bit uncomfortable as well.
So Dr. Mabai, so the decision whether to vote in favor or not is a committee decision.
It's a committee
It's not an
decision.
individual
Yeah. So we can recommend, but at the end of the day, the decision lies with, yes.
Thank you so much for that. Right, let's see what the business rescue practitioners have to say. Patlani? give us your inside track. Let's us understand from a business rescue practitioner's perspective. When you're appointed, you get your notification from SIPSI. What do you do?
Yeah.
So far as SARS is concerned.
So thanks. So as you said, there is a dedicated email address. So when you get appointed, you don't know who has been assigned to deal with that specific matter. So what we normally do is there is that dedicated email address which when we send notices, we will just send to that dedicated email address once they receive on their site. And I must say that there has been a lot of improvement from a communication perspective. From SARS, they respond quicker these days. I've seen where you get someone from SARS contacting you within a few days after you have sent out your notices, and then once you have those notices, or once that person contacts you, you will immediately add their name and their email addresses in the email distribution list, but you still have to make sure that you copy the same that central email address, because sometimes you find that that person has left or resigns in the middle of the process, and now the notices are not getting through.
Are you waiting on SARS for information before you do your VAT returns and you do your outstanding income tax returns? Is that information you receive from SARS, or do you get straight into the books and start doing it and become proactive and send the returns through without being prompted by SARS?
Yeah. So one of the things that we do is that to the extent that we are able to identify and pick up which returns are still outstanding, because one of the biggest challenges that we face as business rescue practitioners is that we come at the tail end when a lot of things have already gone wrong. Now, SARS places expect the practitioner to step in and be able to file all of those returns without affording the practitioner an opportunity to apply his mind, to also make sure that whatever he's putting on whatever is being submitted, it's accurate.
Yeah.
So those are some of the challenges that we experience.
I think from your perspective for SARS is there might have been animosity in the past between the company and SARS. You come in with no history, you come in fresh, and it's your job to try and clean all these issues up as quickly as possible and pay all the creditors in accordance with an adopted plan. So you don't come with the animosity or the history that comes with the company in the past. Yeah.
Exactly. So like I said, I come at the tail end. A lot of things have happened, and you are now at the helm, and you're expected to clean up. You're expected to engage, and like she said, the engagement, the level of engagement have improved in the last. In my experience, compared to, in the last 12 months, compared to the past 3 years. So you're able to get someone to talk to engage, and come up with or explore different ways of dealing with certain issues. I'll give you an example. I was involved in a matter recently where we could not file the annual or the financial statement that had not been finalized, that had not been audited, because the auditors have not been paid. So they have not finalized, and you need to file the returns. How do you do that? Now, one of the things that we discuss with SARS is maybe let's work on the basis of the management accounts, and from there we can assess whether that information will enable SARS to quantify their claim, so that they're able to participate in the BR process.
Fantastic. Thank you. Yeah. Right. So don't fight with the BRP. He's not the bad guy, or she's not the bad lady. They just came in and they're trying to do their best. They got no axe to grind at that stage. Thank you. All right. I want to move on to a separate topic now, and I'm going to ask both the BRP and firstly SARS. Excuse me. What are the 3 most important or most difficult issues that you encounter when dealing with a business rescue practitioner? What would you highlight as those 3 burning issues? Thank you.
Okay. Am I audible? Oh, okay. But I've got a very big voice. Yeah. I think, Pashani, you've quite indicated the issue of the Austrian returns, non-filing of the Austrian returns. And for us, it's really a big issue because it's a non-compliance issue that we can't really avoid. We can't even, because immediately when you start to work with the matter, and the first thing, we look at the hygiene. We look at whether or not the company is compliant and all that. So we find that, I think, I was just looking at most of the matters that are coming to me when we have to sign for the proxy as well as per the mandate of the committee to say, we've seen a lot of matters where we have to vote against the plan because there is an outstanding return, and also the business rescue practitioners as well having to still continue and publish the plan and not even making any arrangement with SARS in terms of Australian return, how you're going to file it. And as a business rescue specialist, I'm sitting there, I'm saying, but how do you now expect as well, how do you also say that I'm able to rescue this company without even knowing how much do you owe me as South African Revenue Services? So it's quite extensive. It's
number one.
Yeah, it's number one. And yes, you've got your reasons, but you know the position that, you know, and also with related to the Australian return, we've seen number of instances where the post business rescue liabilities are not being paid. And yeah, so it's quite problematic on our side.
Is that number two?
Yeah, no, that's still number one because
Okay.
it's Australian return. Yeah, yeah. So the non-filing for us is a problem. And second one, I must state that it's let me. I'll take the law after. We have matters that are sitting in court where the business is still continuing to trade. And obviously we've applied, and there's still that battle between the businesses, between the company and the creditor who has applied for that company to be placed in rescue. And the court still needs to decide whether to place this business in rescue or not. And yet, again, the company is non-compliant and still continue to trade. So it's a bit problematic because those matters are standing still for years now.
That's
and you can
before
finalize
the
it.
BRP is appointed.
Yes,
Okay.
yes, which is a big issue.
Okay.
Yeah. And then the third one that I need to, I've got other, but you said three.
I'm only going to find.
But we're still going to have meetings.
I'm sure you got lots.
So it's the elephant in the room.
As
The third one.
As we discussed, there's lots
Yeah,
of, we've got
the
a herd
third
of
one.
elephants.
Yeah, the elephant. So the third one is this, the fact that business rescue's got a lot of gray areas. So there's this different interpretation of the law. We have to admit that we've got accounting side of you, we've got a legal, and we've got, here we being obliged to treat the matter within the Tax Administration Act. So you find that there's back and forth in terms of arguing, you know, this is a position, this is our position, this is not how I'm understanding it. So at the end of the day, the matter stalls for a very long time. We're not going anywhere. So those for me.
So it's uncertainty because of the law.
Yes.
And you'd like the BRPs to engage with you so that you can
Yes.
deal
Yes.
with these uncertainties and get past them
Yes,
quickly.
yes.
Very
So
interesting, very
that's
interesting.
where we become stuck from our side.
Very
I don't
nice.
need my colleagues to fine.
Khalid, Ashley, anything you'd like to add there on the three issues?
I think there's really a number of other issues that is quite problematic to SARS. Foremost, I think the information that's required by SARS. I sometimes wish that practitioners could understand that we are creature of statute. We've got to apply the law as it stands. And in as much as the practitioners hold out there that, look, they've also in this limited time period, rushing to try and save a business. They've got to appreciate that there are tax consequences. Every business rescue matter has tax consequences. So we appeal to the practitioners out there that, you know, we don't expect them to be experts. They earn good enough money. Yes, I know that's probably another issue. I mean, like, if we say it's good enough, you can well imagine where we come from. So, look, I think that insofar as the tax consequences are concerned, there needs to be a bit more collaboration between the business rescue practitioner and never mind SARS, also tax advisors out there. I'm sure you guys have webinars, we discuss tax issues, etc. And we'd appreciate it if the tax side of things are impressed upon business rescue practitioners who perhaps don't have a tax background. It's of vital importance because it makes the job on SARS side a bit easier. How much easier, I don't know, because there are many disputed tax issues currently. And I think it's like Dr. Mabasa said, you've got these different interpretations of the law, and this creates that tension. And, you know, the fact that, okay, I don't want to deal with SARS because they just don't understand, but we do understand. And what needs to be appreciated from the business rescue practitioner side is that in us applying the law, we'd like to accommodate business rescue practitioners as far as possible. But we've got to make an informed decision. I mean, like the Companies Act itself says, it sets out the requirements for a business rescue plan. Now, if any of the business rescue practitioners have taken the time to actually go and check what SARS has got to consider, it's not only the information in the business rescue plan. We are bound by the Tax Administration Act. And the Tax Administration Act will tell you, SARS, when you consider whether to support or not support a business rescue plan, take into account all the aspects that you've got to take into account when looking at a normal compromise. So when we look at that, at the very outset of business rescue, when we send you a proof of claim, you get 3 documents generally. It would be the proof of claim. You get a request for information as well as the submission of outstanding returns. Those are not just nice documents that we're including there. And we'll also include a really nice request for you to consider certain standard clauses that we'd like you to insert in the business rescue plan. Now, from my personal experience, you know, I sit there anxiously awaiting the response from the business rescue practitioner. And you see that, you know, it's the letter that we send out is, in terms of statute, we are requesting you to submit information within a period of time. And we'll tell you, please submit this within 10 days. Now, when we send that, we would have expected that, and, you know, we've attended some courses at Pretoria University, and Professor Pretorius will say, you know, the integrity of information is important. And the business rescue practitioner, when he starts out, there must be some form of consultation. They must know what is happening in there. And that's an expectation. Surely a business rescue practitioner, you must tell us, do you have some form of consultation with the company? Do you speak to the directors and say, okay, what is the problem here? You've got a sworn statement of facts. It sets out what the reasons for financial distress are. It sets out that there is this supposed reasonable prospect. And, you know, even the issue of reasonable prospect, the law, in as much as some see it as quite clear, all of a sudden SARS feels like, you know, the adopted child. It's like, okay, we here as well. Have you considered the taxes that's outstanding here? Have you considered the outstanding returns? Have you inquired about it? So when you do your health check on that company, when you do your assessment as to whether that company is actually whether the prospect of saving that company is real. Have you considered the tax side of it? Have you looked at whether there's outstanding returns? Have you checked those financial statements? That is the problems that we tend to face. And unless it's really looked at by a business rescue practitioner, you're going to find down the line in that very limited period. I mean, like we get reminded, probably on convenience, that look, we've got a limited time here to do everything here. When the time comes closer time that the plan must, by the first meeting of creditors, look, I must still investigate the affairs of this particular company. So we're seeking an extension. But listen, what have you done thus far? No, we're still investigating. So I only know of about 3 or 4 matters where a business rescue practitioner has come in. It's maybe just a bit of luck. He comes in, first meeting takes place. He says, I've been appointed then, 25 days later, you'll have your plan. And the plan, I swear to you, it's published on time. And in those few matters, the tax side was also looked at. Okay, lucky enough, I think everybody was offered 100 cents in the rand. And that's not always the case. But from SARS's side, we have many burning questions. What do you actually do? Paflani says that, look, he comes in and he will make sure that, the notice goes off to SARS as well. But we also want to know, what do you do behind the scenes? What is it that you are looking at? Is the standard in respect of what you need to save a company just a few items, sans the particular tax issues? Because we're also an affected person. Yeah. And in business, you've got to pay your taxes as well. What importance is extended to the tax side of things? I've had many discussions with many business rescue practitioners, and you get the sense that, a few years back, it was much of a tension. SARS, and they look at you and they just walk away. Recently, I think people have been more forthcoming and they're starting to understand where SARS is coming from. It is important. So the biggest challenge from SARS's side is whether an emphasis or a focus is placed on the tax issues that, for pre-commencement purposes, and how that played a role in the financial distress. Invariably, you're going to find, I'd say 95, 98% of the cases, there are outstanding taxes. Do you focus on that? Do you ever ask, why are these taxes outstanding? You know what we find strange is when we get a sworn statement of facts and we look at it. And in many instances, it's about 5 lines. And you say, okay. So, and you compare it to what you're looking on the tax account and you say, but you've got that, there's liabilities here. Returns have been submitted without payment for the past 5 years. And in some instances where SARS is probably the biggest creditor, and they'll actually give you a 1-liner or 2-liner to say, well, you know what, the company just didn't have money, and they actually use the taxes. Yeah. And you say, you're saying this under oath. This company actually used the taxes for cash flow of the company. So you sit there and you think, okay, so you're admitting to statutory offenses here. Where do you think we're going to start? What is expected from SARS? SARS, look, you know what? There is no further money in this company, so we want you to write off everything here. We've got to mitigate loss to the state. We've got to ensure that taxes are collected. We've got to ensure that taxes or returns are submitted timeously. It's a huge problem for us. But, I think that's the nature of the beast, business rescue. Yep. You've always going to have outstanding taxes. It's how I think the business rescue practitioner stepping in looks at that situation and say, what am I going to do about this? Because, you've had a recalcitrant taxpayer for so many years. What are we going to do to rectify that? We see many, many, many business rescue plans where the directors have probably abused or flouted tax laws. And a plan, that business rescue practitioner has a plan for it. He's got the experience. I say it takes a special breed of person to be a business rescue practitioner. He's really got to know law. Okay. He's got to know accounting and he's got to know business.
Correct.
And it is such a challenge for business rescue practitioners. But that is why you are paid that much per hour. So when you get paid that much per hour, then, you know, you've also allowed to actually go and pay, you know, people who can assist you. I mean, like we see that in the remuneration agreements, but you guys get paid a lot. And, you know, despite inflation and the fact that the Act's been promulgated in 2008 and there's not been any changes to regulations, etc., we feel your pain. And imagine the pain that we come from if we're saying you earn a lot. But more seriously, look, I think from what we really need from business rescue practitioners is that when they get a business rescue matter, if they consulted about it or on it, then have a look at the tax side. We are also important.
Yeah.
You know, we represent the SARS side or the collection side of the state.
Excellent. I love that. I don't know what you would. But what you want is more transparency and more contact from the business rescue practitioner, and things should then go smoothly because you have a lot of unanswered questions, and if you get the information, you can then make an informed decision.
Yeah.
Thank you. Thank you. Ash?
Just to close off the thought, it's just to say that, and obviously I'm teaching to the converted here in this room, but it's to understand that business, you know, to say what Khalid is saying, one of the big issues we have is that we've seen taxpayers who have tried compromises, who have tried settlements, who have tried all sorts of things with us. And then somewhere along the line, a person who's not in this room comes to them and advises them that business rescue is the way to deal with your tax affairs. And we know.
Is there something wrong with it?
But that shouldn't be the purpose, though. and what you're trying to go that way, but we're going to bring you back, and that's what we're trying to do. Yeah.
Fantastic. That was lovely. Thank you, guys. Thank you. Atlana, you're not off the hook here. So you had a nice break. Yeah. What are the 3 big burning issues that you have with SARS as a BRP?
Yeah. So I think, again, it goes back to what I said earlier on about, you know, practitioners coming at the tail end. Now, one of the things that we find it very difficult to deal with, it's firstly accessing the e-filing. Because you find that sometimes, you know, the login details or the e-filing details are with someone, you know, and that person can't be traced at the time. You have to, you know, provide all this information. You have to, you know, file all these returns. Sometimes you'll ask SARS, can we file this manually? Then they will tell you, no, you know, it has to be, you know, via e-filing. We have the information, we're ready to file, but, you know, the fact that you don't have access to e-filing, that is one of the biggest issues that, you know, we're sitting with at the moment. And I think if that can be looked at to say, you know, once a practitioner is appointed, you know, maybe you need to allocate or reset the passwords and give, you know, the practitioners access to the e-filing system, because then it will make our life much easier. Yeah. The second biggest issue that we're sitting with, it's the tax clearance. Now, you know, when you're dealing with when you're dealing with some of the companies that are doing work with the public sector, and sometimes, you know, they use what they call I think there's a system that they use which, you know, checks your tax status on a monthly basis, and before they release the payment, they need to check your status. And now, you know, you have been rendering a service. Come at the end of the month, your payment is blocked because you don't have access. Now, SARS will tell you, look, you know, you need to enter into an arrangement. We said, well, look, you know, we can't enter into a separate arrangement because we are in business rescue. They say, well, look, you know, it's our policy we enter into an arrangement and you must pay us. We say, well, look, we need to be, because these are the,
Dr. Mabasa smiling.
yeah, and some of these issues, are the pre-BR debts, and they want to enter into an arrangement, and they say, well, look, we want payment before even the plan is, published. So basically, you say, well, look, that will amount to, treating SARS, as a preferent, creditor, because then now you're preferring them over the other creditors. So it's one of the biggest issues that we're sitting with. And now, you find that, the business will end up, coming to a standstill because you can't access the
third burning issue.
The third one, I'm not sure if I'm the only one who have experienced this, but in certain instances, you find that you publish a plan, you have taken, SARS through, they're happy with everything, but they still come and vote against your plan, even where they're getting paid 100 cents in a rent.
They've covered themselves. That's the committee decision.
And now you ask yourself, did they understand the plan or what? And it's some of those challenges that, when I'm sitting on the other side, I'm asking myself, what's going on here? Because one, all my tax returns have been filed. Two, I'm paying you 100 cents. I'm not even compromising you. I will understand if I was compromising you. We had, I can give another example where, without mentioning a name, obviously, without mentioning the name of the client, where, SARS had, their claim was about 4,000 rand, and they were going to be paid 100 cents in a rand. Everything was filed up to date. They still came and voted against the plan. So it will be very interesting to understand,
Yeah.
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 I'm sure that sometimes to a business rescue practitioner, the plan looks perfect. And we look at certain other tax consequences, and perhaps they are advised by their tax advisor that, from a tax perspective, this cannot be challenged. And we find ourselves challenging certain issues. And that is perhaps why SARS would have voted against a particular plan. I think it's important that our business rescue practitioners out there actually be cognizant of the fact that SARS is not there as some form of opposition to business rescue. It is certainly not. We'd really love to support each and every plan. And we won't nilly-willy decide to vote against the adoption of the plan. The party ban issue, many times we express it by email. And if it's not addressed, then unfortunately we are obliged to vote against the plan.
Who would like to address the e-filing? Why can't a BRP substitute himself for the management or the directors who are on the e-filing system? What is the problem? I mean, it would make things flow much quicker and much easier if the BRP could just pull off the old. And I understand that you'd have a problem dealing with old management, but if the BRP takes the old management off the e-filing and substitutes himself, why can't that work?
Colin, I think that there have been some business rescue practitioners who probably had the luxury of knowing me. Sorry that I've got to personalize it. But in the Western Cape, I've built up a bit of a relationship with a number of business rescue practitioners. I think some of them are probably watching us online who can confirm that, it's a huge organization, and what you business rescue practitioners are actually advised at the in-house accountants there or the accountants as to how to go about doing things, that they're actually going to struggle, and they're going to see the changing of the E as a problem. And it's case specific, because you might have where you have the retrenchment of an accounting officer at the start of business rescue. That person had the e-filing passwords, etc. And all of a sudden, the business rescue practitioner sits there and he says, okay, SARS is starting to warn me that I've got to submit returns. SARS, we don't have the particular profiles. Or they perhaps retrench just before business rescue. There are other factors as well that when a company is registered for e-filing and there needs to be a change in the person or the public officer, etc., the representative of the company, there's a process to be followed by SARS. And at this point in time, the Business Rescue Division has actually asked meetings with our portfolio maintenance departments, etc., that manage these things, and taxpayer service departments. And what you find is that they will say, look, we work according to a SOP. It's not in the SOP at present. And business rescue practitioners might think, well, that's a shortcoming on SARS side. It needs to be fixed. But within the context of business rescue itself, we all know it's a very short period, although many of the cases drag on for years. But in terms of legislation, it's supposed to be something that can be completed within 3 months.
Correct.
Many instances, these matters get extended or postponed, or at least gets extended for about 5, 6, 7 months. So what you find is that the law and the processes internally for e-filing, for changing of the various profiles, etc., and the changing of who the representative of the company is, because of the short space of time, they say, or at least say, look, there is a process that can be followed, a normal process. Business rescue does not make you special, although we're crying out, look, we need this to be expedited. So coming back to the first thing that I said, because we've only been centralized now for the past 12 to 18 months, what we've started noticing is there are repeat issues that's coming up. The e-filing issue is an issue. What I've done, or what we've done from a SARS perspective, is the moment there's an issue of that nature, we'll find somebody who can assist us. And we say, this needs to be fast-tracked. It is urgent. You need to expedite this. We're hoping within the foreseeable future, the near future, that we can get a dedicated person to deal with it. Alternatively, perhaps a bit of education from SARS to tell business rescue practitioners. That'd probably be the easiest way to go about it. This is how you go about changing the e-profiling profile as well as passwords. I think that would be important from a tax or SARS education side. Perhaps something can be set up that just changing a password requires the following. Once you've got that, because there are companies where you don't have accountants or they don't want to help you because they haven't been paid yet. So is it possible to change passwords? Yes, it is possible. The representative does play a representative taxpayer does play a major role with it. But it is something that we have identified as a problem. It is something that we are working on. And hopefully within the next short period of time, we'd be able to overcome that issue with yourselves.
Well, if we achieve that only, that's a great benefit. Thank you.
In the meantime, like
Can you switch on Dr. Mabasa's mic? Thank you.
So in the meantime, because you would have a specialist working on the matter, you would know who's dealing with your matter, then you do escalate to the business rescue specialist. And if there's any problem, I think Mr. Buhle as well also assist in facilitating that, and I can also help with at least for you to resolve it. Because also there's on a SARS website, there is also a way in which you as a business rescue practitioner can be able to access that. But we know that sometimes also it's your details on the system that are not updated, you know, all those kind of things.
Yeah.
But if you struggle first, please. And then, then you learn it.
Fantastic. This is great. Thank you. All right. Let's go to a few when we were discussing all the elephants in the room on legal issues. Guys, please, we're not making law here. It's not policy. We all encounter the same difficulties as BOPs and advisors, as lawyers to BOPs with SARS on these issues. We had to have an open and frank discussion. So the first thing is going to be the timing of tax. I'm sure you all have an issue with that as BOPs. And what I'm referring to in the timing is all the activity for the tax event takes place before the commencement date. And insofar as income tax, as the first example, the BOP renders a return afterwards and gets assessed afterwards. As a BOP, the question will be, do you want that to be treated as pre and get locked up into the moratorium, where I think it should be? Or as we see SARS taking a view that that should be post, because the assessment only came out after the commencement date. So I'm going to open it up to the SARS floor. You're not committing, and no one's going to put this in any case against you in the future. What is your view? Do you treat it as pre? Do you treat it as post? Are you divided? Just give us the inside track on that, please. Without prejudice, off the record.
Look, Colin, this one is one of those things that Tabia was speaking to with regard to the grey areas of law, quote unquote. We know that the Companies Act uses the word owed, and we don't have that language in any of the tax acts per se. So we have had to work out a way to marry the two acts, because we are administrators at the end of the day. And what we have established as a business practice, and this is what we do, is we basically, for self-assessment taxes, we're looking at the due date for the return, and that will determine whether or not the liability will fall under the pre or the post section. And then for tax that we assess, which is basically income tax, we would look at the due date in the notice of assessment. And that's sort of this line in the sand that we've been able to draw thus far. We know and we appreciate that there are differences in opinion in the industry. And at this stage, all we can say on that is, in the absence of any legislative amendments, which we really hope that we can push for, and which we are trying to push for on our side, but in the absence thereof, we'd have to wait for a court decision on that to clarify exactly where that line is, because we know that you have your view and we have our view, and we'll just have to see how it goes.
Thank you. Thank you.
Yeah.
Your view from the BOP's perspective.
Yeah, I think from the BR perspective, one, the act is very clear. I mean, if the debt arose prior to the commencement of business rescue, that debt should be dealt with as part of, the pre-commencement liability, and should, be part of the moratorium that is applicable to all the pre-business rescue debt, because irrespective of whether the assessment it's issued at a later stage, but we must look at when did the debt actually arose. It's like, if someone is rendering a service, the fact that they issue the invoice post BR, whereas the service was rendered months before business rescue, should not then elevate them to a post business rescue, debt. We must look at, when did the actual liability or debt arose. That would be my view.
Yeah, we'll never resolve this here. I know that. And this is going to be sorted out in court, or as you say, if there's going to be legislative amendments. There is a Section 5, though, in the Companies Act. It sits on our side.
That there is.
Yeah. Thank you. So I assume that, in your view, applies both to VAT and to income tax.
Yes.
Or is there a difference in timing?
Yeah, we spoke about the VAT, the self-assessment taxes. VAT and pay as you earn would be self-assessment. Income tax would be where SARS assesses, basically. And then we issue a regional assessment. And then that one, we'd look at the due date and the assessment itself.
So for VAT, you would wait for us, the BOP, to put in his return where he claims back his VAT, and that you'd say is the date that
we'd look at the due date for that return. So whenever the return was due, that's how we allocate where it was. So if the
due date of the return.
Yes.
I think for purpose of understanding, business rescue practitioners think that if there are outstanding VAT returns for the past few years, that when they submit it, that SARS is saying that all the liabilities stemming from those returns are in fact post-commencement. That's not what SARS is saying. SARS is saying that there's a due date for that return to have been submitted and paid. And that due date is the one that SARS is actually looking at. I think where the tension arises now is the time that the company goes into business rescue. And I think we've basically brought it down to just that specific period. And it's not necessarily all returns prior to that that's not been outstanding. That's been outstanding that we are saying is post-commencement. No, those are pre-commencement. But the real elephant in the room is that date that the company goes into business rescue. You find, depending on what time of the month it is, if there are VAT returns that submitted just after that, SARS is saying that we look at when that return has been submitted, when it was due, and we'll regard that as a post-commencement liability. And it's quite strange how much emphasis is actually placed on that and how this company is really going to die if they're going to have to actually pay that amount. And I'm not sure whether it is the case, whether that is the case, or whether it's actually going to affect the remuneration agreement. You know, because if that goes to post-commencement and that has to be paid to SARS, it's going to affect the remuneration agreement. So no. In all honesty, look, it's sometimes we oversimplify things. And, you know, if you look at it, there might be business rescue practitioners that actually deal with matters where that month's VAT or pay as you earn could have been great cash flow in that company for the first weeks when they've got to claim the retainer. But, you know, it could be the lifeblood. But once again, we are asking the business rescue practitioners that there's been such a focus on SARS and what SARS has got to do to actually assist, because, you know, this legislation was drafted for purposes of actually trying to avoid liquidations. And for, you know, we all know the benefits of continued trading of a company. We're not going to go into that right now. But what is important is that we do appreciate that the company does need that money, and they focus on SARS, but they don't focus on the issue of PCF. There's a whole section in the Act that deals with post-commencement finance. And we're not sure if it's because there's just a continuum of, look, SARS has been used as a credit provider for the past 2 years. So if we can continue with that now, we don't have to worry about actually approaching a bank for PCF. From the outset, look, I say this tongue in cheek, from the outset of business rescue, it becomes almost too convenient to blame SARS for the woes of business rescue. And we actually find it quite strange that after so many years, that the banking industry has not looked at this as, wow, here's an opportunity. I am a super preferent creditor. You know, there's been no focus on that. And what has the industry actually looked at to ensure that banks would be comfortable, or financing houses would be comfortable with actually supplying PCF? So, you know, there's this bit that the business rescue practitioners also ask themselves. Do we blame SARS for all the woes in business rescue? Or do we blame ourselves for actually not looking at the rest of the legislation that's contained in Chapter 6 for why you do not have that lifeblood? So it's a very valid question that we're asking.
Would any of you like a nature break, because we've got another hour to go? Does anybody need a nature break with you?
No, I think
You all all right?
yeah.
Okay, you all okay? Good. Right. I'm going to now deal with the other part of the herd.
It's fine.
Settle.
Yes,
Okay.
go for it.
I know that all the BRPs here have experienced on your side too, that we're assuming now that there's tax due to SARS before commencement, large sums, and there's tax back to the BRP for post-commencement trading. So there's money due by SARS to the BRP for his post-commencement trading and everything else he's done. And locked up in the moratorium, is substantial money is owed to SARS, VAT, income tax, maybe PAYE, and SARS then says, I'm going to settle that post-commencement money that I owe you against what you owe me pre.
Check that.
I know we're never going to resolve that. Everyone understands it.
So while
Have to resolve it.
No, look, Colin, we received your papers and we're busy with you, but it's fine. We'll try and answer the question. Would you like to answer?
I'll deal with that
Thanks,
one. With regard to set off, yes, it's always interesting, these business rescue issues. When it comes to set off, our position is that Section 191 applies automatically. So there's nothing that we do as SARS in that we don't take the decision. This is just how the law operates. And what 191 says is that when there is an amount that is due to SARS, and a refund becomes available, then SARS must treat that amount as a payment. So there we don't have any discretion insofar as what we can do and what we can't do. It happens by operation of law. And that's sort of where we see sometimes that then they come to us and they tell us, no, you want to be preferent and this money belongs to the company and that type of thing. We understand, but we also, and I'm going to say this again, we are tax administrators and that's what the Tax Administration Act says. But there are exceptions to that law in Section 191, and those exceptions relate to when the debt is subject to suspension of payment, subject to compromise, subject to a payment arrangement. And now once a business rescue plan is adopted, then we regard that as the debt being subject to the compromise arrangement or payment arrangement that is in the business rescue plan. And after that stage, we will no longer be setting off in respect of whatever debt has been ring-fenced in terms of the business rescue plan. That doesn't exclude your post-commencement debt. In that regard, that debt is due and payable. So if a post-commencement refund becomes available and you have post-commencement debt, Section 191 will find operation again. So yeah, that's basically how it works.
Yes, I would argue with you Section 197 and 198, but that's for another session, and I hope you're going to come back and you've had good fun today. We're going to do that as a proper workshop.
Part two.
As I understand you, Ash, what you're saying is the adoption of the business rescue plan is the very important step.
Correct.
In the
yes.
settle.
Yeah.
Because once we're bound as an agreement under 154, we're bound to get our dividend, and that's all we can get. And insofar as anything else, we can't apply it as a payment or a settle.
And we accept that 100%. We accept that, and that's how the law operates.
Thank you. You're not off the hook there. What's your view on the settle?
Yeah, I think again it goes back to because once a company goes into business rescue, there is that moratorium. So therefore, no one should be allowed to set off. Creditors, I mean, all the creditors must be treated the same. You've got two classes of creditors. You've got your secured, you've got your general, so concurrent creditors. Now, once that it kicks in. Now, the SARS must just participate in the process, and they must wait for, their dividend, if there is a dividend that will be, coming, because I find it very difficult to understand why would SARS want to sort of, be sort of a superior concurrent creditor in a business rescue proceedings, because unlike in liquidation, they're not a preferred creditor so they can't be treated. Otherwise, then you'll have a situation where all the other creditors will then say, well, look, I'm not going to pay you. I'll just set off from whatever, you owe me or I owe you. So it just becomes messy and in my view, it defeats the whole objective of business rescue.
Sorry,
Ash?
Colin. I just want to the point. I just want to emphasize that this is not something that we decide to do. It's just how the law operates. And
No one's saying you're wrong.
I know.
No one's saying you're right. As you say, this is going to either come away with legislation,
Yeah,
be fixed up, or there's going to be a court case that goes all the way to the top again.
100%.
That will
be
sort
very
out the
interesting.
issue once and for all.
Yeah.
Thank you. All right, we'll stay away from the elephants now. Let's just ask. Go to SARS. So we all know that under Section 99 of the Insolvency Act, you've got your statutory preferences in liquidation. And we all know that the Insolvency Act has nothing to do with Chapter 6. You can't bring it in and you can't apply it. And all creditors, except for secured creditors, appear to be treated equally in rescue. So we all know that a business rescue plan has a liquidation dividend calculation, so the creditors can see whether or not to accept what's being offered and that you're beating the dividend that they give in liquidation. If you see that you're getting a better dividend in the liquidation account, as you would as a dividend proposed in the rescue, would you push for liquidation or would you support the rescue? Well, difficult question. I suppose every case is different, but just as a general, are you in favor of rescue as opposed to liquidation? Do you support it? Or would you prefer liquidation because you treat it at a higher level and with more preference?
Colin, it's quite strange that you ask a question like that. Look, first of all, I don't know if it's a misperception about, SARS has got this preferent position in liquidation. So I guess the reason why you're asking a question is because business rescue practitioners are probably looking at business rescue and saying, well, SARS is probably not supporting our plans because they get a better dividend in liquidation. The strange thing is, however, I think in 95% of the cases, when you receive a business rescue plan and you look at the liquidation scenario, you actually find that in most of the liquidation scenarios, SARS are told, you know what, you're actually getting less than what you get in this business rescue. So from that perspective, we don't tend to understand the question.
Okay.
Yes, we certainly more in favor of business rescues.
Excellent.
There are, however, matters where you actually find that SARS is told, SARS, you in liquidation, you're entitled, or you would get 100 cents in the rand. And then you'd look at the business rescue scenario, and SARS actually offered 15 cents in the rand. And I think what we'd appreciate the business rescue practitioners looking at is that in terms of legislation, when we consider business rescue plan, we are not just supposed to look at the plan. The Tax Administration Act obliges us to look at the various compromise provisions and the aspects of compromise. And therein lies the issue of if we support the plan and the compromise, or can we support that plan to get 15 cents in the rand? Whereas if we were to look at normal collection steps or in inverted commas, in a liquidation, you are going to get 100 cents in the rand. So if the law obliges us to only compromise where the compromise amount, the offer to you, is greater than what you'd get through a normal collection, then we're obliged to go with the compromise. If, however, through normal collections, you are going to get a greater amount than what is being offered to you, then you cannot compromise. There are not many cases where SARS is actually told, I'm offering you 100 cents in the rand. And I challenge the practitioners here. Show us where the business rescue plan is actually provided 100 cents in rand in liquidation and a much smaller amount in business rescue. There'd probably be a handful of cases. And when I say that, I mean for the past 10 years. So, you know, the question that you pose to us, are you more in favor of liquidation? No, we're not. We've got to look at the letter of the law. We are obliged to look at the Tax Administration Act. And yes, we are more in favor of business rescue, provided that you deal with the tax issues the way it's supposed to be dealt with.
Fantastic. Thank you. Dr. Mabasa, would you like to add anything, or Ash?
No, I'm fine, thanks.
You're not off the hook?
Yep.
But what is your experience with dealing with SARS now in regard to rescue? Do you find them more cooperative, more approachable, more in favor of rescue now that everyone's starting to get an understanding of what rescue is all about? It's filtering through.
Yeah.
What is your experience?
Yeah. So I think, again, in the last couple of months, I've seen sort of a slight change from SARS's approach in terms of, you know, dealing with business rescue and liquidation. I mean, in the past, SARS was not was sort of rigid, not flexible enough to look at, you know, various options that are being, you know, put in front of them.
Brilliant.
It was more like, you know, a tick box exercise and approach kind of, and it made it very difficult to engage from that perspective, because it was like, you know, it's either this way or the highway. But these days, you know, there is that
Fantastic.
willingness to engage and I can, you know, agree with or support what Dr. was said earlier on, to say, well, look, you know, they are moving towards, you know, bringing centralizing and making sure that you know, their team is well capacitated, they understand the BR process, and I can attest to that you know, the attitude and approach has slightly changed, and I think, you know, there is more support coming from them, and they're asking the right questions, and, you know, you're able to engage with them, unlike in the past where it was, you know, no, it cannot be done.
Wonderful to hear. Thank you.
Yeah, like I said, also maybe over and above the specialists that we have, we've indicated that business rescue actually is three-legged, where you look at the business, where you look at the accounting side, where you look at the legalities of it. So we also we strive to bring everything together, because most of the time we've been threatened. I don't know, maybe it's a way of, I don't know how I say it, but the common phrase is people lose their jobs. There's a common phrase, and, you know, we sort of feel pitied, so people mustn't look at. But sometimes we find that you postponing the inevitable. You know, if you look at CIPC, Renee would agree with me that the figures in terms that we always require to say how many businesses that are in rescue that are actually have been rescuable, have now they're being rehabilitated, they're back to business. And you'll find that the figures are just, so is it you killing time? Is it this business actually supposed, it is, I'm saying that it's going into liquidation, you know. So like Mr. Buhle has highlighted, that this variety of things that we're looking at, but also looking at the present and the future.
Excellent. Yeah, there certainly are advantages to rescuing a company from SARS perspective as well as the economy. And if SARS are alive to that, that's really reassuring. I must tell you, thank you. Thank you very much. Yeah. And it's good to hear from Vani that there's this warming up and this understanding and this communication you're having. I hope it grows, and hopefully this seminar is a start of something like that. We can speed up the business rescue process and act in your interest and in the BRP and the other creditors' interests as well. Guys, I'm finished. I try to keep it very high level and interesting. We will allow for a few questions, but please, guys, treat SARS with respect. Don't pin them down on anything. We know that the differences on very important issues in the law, they're not here to solve it. They're not here to give you policy. We're just here to interact with each other. And if you want to ask a question and interact at that level, please feel free to do so. Thank you. One brave man. Is this coming out of the herd of elephants there?
Maybe. Thank you very much. Thank you, SARS. I've just got 3 questions, questions or scenarios that I come about in practice as a BRP.
Identify yourself so we can get your tax number, please.
Thank you. My name is Gideon Slabbert. I practice in turnaround rescue solutions. And my one question is, if we look at Section 135 of the Companies Act and post-commencement finance specifically, it seems to me as if in practice that term is thrown quite easily. It's just stating, okay, now it's after business rescue, it's now post-commencement finance. What is SAR's view on that? In my view and opinion, if anything is post-commencement finance, there should be a specific agreement with the specific financier or creditor and the company. Because if you go into liquidation, what protects the financier for securing that preference as post-commencement finance? So is it a matter of a post-commencement finance agreement that needs to be reached between SARS and the BRPs, or is it just post-business rescue obligations that needs to be paid in the ordinary course of business?
Sure, that's a difficult one. I wonder if anyone could answer that. That's a hard one. It's a good question. Very young.
Just let me understand, what was it that you asked? Is there some sort of an agreement that we should enter into?
Sorry, if I understand it correctly, under Section 135, there's post-commencement finance. So if there's VAT and if there's income tax post-commencement or a financier, how do you protect whether SARS or the creditor against a future liquidation that you preserved your rights as securities, I understand you, if the company goes into liquidation after rescue? Is that correct?
Yeah, that is basically what I'm saying.
Sure.
Is it automatically post-commencement finance or is it a post-business rescue obligation?
Oh, okay. See, it's difficult because there's no definition of what post-commencement finance is, and that's why it's like, okay.
Yeah.
And there is this gray area insofar as how do you classify that liability? You asked what is SARS's view. I can't give you SARS's view, but I think I would classify it as a post-commencement obligation. And that is why post-commencement liabilities is such a sore point for us. It's because we know that if you take this business rescue on for too long and it's inevitable that it's going to be liquidated and you're just racking up these post-commencement liabilities as a business rescue practitioner, you are creating a bigger problem for us later on in the process. I think how we've tried to address that now is that we're looking into personal liability. And we're looking into it more serious. I know we've said it in the past, but we are seriously looking into personal liability and how far we can extend it insofar as directors for pre-commencement liabilities, but also business rescue practitioners for post-commencement liabilities. That can be part 2 of the discussion.
Mr. Slabbert, question number 2.
My third question, which I'm going to ask second, is if you look at the set-off, or we discussed the topic of set-off, that's obviously SARS owing you money versus the other way around. Is inter-tax set-off also something that SARS would look of, and saying in the sense of assessed tax, income tax? Sometimes a lot of companies has got a accumulated assessed loss, but they owe on VAT. So in order for you to consider the compromise in terms of the Tax Administration Act, is set-off of an income tax necessarily, or can it be considered in terms of VAT and PAYE? You know, also when you
I think the
publish
question
the
is,
plan.
correct me if I'm wrong, is the question, if you owed income tax and VAT pre, do those set off? And if you owed income tax and VAT post, can you set off the income tax against the VAT post, vice versa? Or are you crossing the commencement date?
No, specifically referring to, regardless of dates, income tax, assessed liability versus VAT payable or PAYE payable.
Yeah. I think we dealt with that in the lecture. There's a difference of views. SARS say yes, BRP say no. And it's
So-
going to get resolved in court at a future date or change in legislation, I think.
So for set off, the TAA doesn't speak to the specific tax type. It just says if there's a tax debt, it must be set off. So we set off against VAT pay as you earn or income tax if
Yeah.
there's a debt.
The interesting thing is section 191. It doesn't talk about set off. It says pay.
Treated as a
Taxpayer
payment.
Pay the tax.
Because there's actually a reference to set off.
In
If
there,
there's further custom and excise liabilities.
yeah.
At the very end, yes. If you left after you've paid, goes to customs and excise.
Yeah.
Yes.
But yes, it doesn't talk about set off, which is a very interesting point. It's a
Very
payment, yeah,
interesting.
Yeah. Okay, your second question?
Yeah, the last question is, you find that you publish a business rescue plan and everyone wants to hold you 100% to that plan. But you are a managing member of the entity and the plan, you need to continuously implement measures to keep the plan aligned in terms of payment. Sometimes you will be in the surplus, sometimes you will be in the deficits. Operationally, you need to make decisions. How does SARS treat the ongoing implementation, as opposed to the plan and compromise? Because in the industry, tend to see it as a cast in stone. And not saying that the debt necessarily is now to change or anything, but if something happens, let's say 6 months down the plan has been accepted, you now get a buyout offer, or you see that this company is heading in the wrong direction. Does SARS then look, or how can we approach as BRPs and say, listen, yeah, SARS, we need to realign the direction of this boat? Does that request go back to the committee and they consider it and come back to the BRP? Or is it then just, from your point of view, plainly a liquidation, the plan has not been substantially implemented?
I think you're probably going to have to look at the plan that you're drafting, and you're probably going to have to look at, what would constitute breach, default, etc. And, I'm not sure what kind of crystal ball you guys are supposed to look at, but you are required to do a 3-year cash flow projection. So we're going to call into question that 3-year cash flow projection if you're saying it's just a nice to have to put in there. What have you done in developing that plan? If you do find, and I'm not saying that everything is going to remain constant, but if you do find that there is an issue in the future, let's say somebody comes along and they're interested and you actually think it would be best for this business to actually be sold and you spoke to the director, then you've got to actually provide for that. And nothing stops you from approaching the creditors after that and saying, look, this is the case. But what type of, from SARS's perspective, we'd actually look at, okay, if you promised, or at least the plan provided for, say, 35 cents in the rand, and we're assuming here that that's going to be paid off over a period of time, and we voted in favor of that plan. If you find 4 months down the line that something has, there's this new impetus that could come into this company, that you feel that this is a better direction to go, if it's advantageous to SARS, why would SARS want to liquidate it? Because your plan said, you will get your money over a 2-year period. And we've got to be realistic to that as well. We won't nilly-willy go and do silent liquidation. It'd be mad. So if your plan provides, like I said, for the SARS debts to be paid off over a period of time, but it comes to your attention that it would be advantageous for SARS to actually reconsider that, and provided that other creditors are also catered for, perhaps in a manner that is going to be better for that creditors, then we've got to be open to that. I hope that answers your question.
Yeah. I think just to that point, there's nothing in the Companies Act that says you can't or you can go and amend your plan afterwards after it's been adopted. And for us, it's a bit of one of those sticky areas because again, these are my words. We are tax administrators, and we're always looking for rules. So where there's an area where we sort of need to be a little bit more agile, like Khalid says, we will consider a revised plan per se, but we do that with a lot of caution because the question will come up: what's changed now versus the first time around, and is this just a dying horse that you're just trying to revive again? And it goes into the question with regard to post-commencement liabilities. So we'd also look at that factor. How have you been treating your post-commencement liabilities up until that point? Because now we're no longer just looking at your pre-commencement history, we're also looking at your post-commencement history. So there's a lot of factors that we need to consider in that particular scenario. But yeah, the answer is not yes and the answer is not no. It would just be case by case. And you might know of the AAD matter with the Western Cape High Court. We were criticized, although we won the matter, we were criticized insofar as when we engaged outside of the business rescue process with the business rescue practitioner and the business rescue plan after we had already voted on the plan. So the court said that once the vote was in, then we should have left it at that. But we went on and we had additional meetings with the practitioner to try and be in the spirit of rescuing the entity, which then sort of turned against us in the end. And so those are the factors that we need to take into account when we have these things come onto our tables.
Thank you. Thank you very much. I think we're running out of time. Just a quick joke. There was a guy who was choking in a restaurant and everyone panicked and they asked for a doctor. The doctor came and he couldn't dislodge this guy was choking on. And a chap at the back of the room put up his hand and he came along and maneuver and this guy coughed everything up. And they said to him, "Wow, are you a doctor? You're a paramedic? Is this a new Heinemann procedure?" He said, "No, I just work at the Receiver of Revenue." Guys, I don't know if you enjoyed this session as much as I did, but this was really a fantastic session. It was.
Collins, I think it's quite interesting, Mr. Strabert, what you're asking. We have quite a lot of matters as well. I mean, when you get status report from our mailbox, sometimes they don't say anything. You know, we do not know exactly whether we're going in, whether we're coming. And most of the time we'll find that perhaps you are in that kind of a position. But if you do not communicate with SARS and all that, then it becomes a matter that is halted for a very long time. And I think most of the time I'll be also concerned about not having any commitment, anything, even with the business rescue plans that we get these days. In the past, when we began, you'll find that they tell you that we're going to pay you for this kind of a period and from this period up until this period. But because of the economy now, it becomes very difficult as well. Sometimes all the transactions that you hope was going to happen, it doesn't happen. And the market as well, you know, you find that the assets that are going to sell now, the value now has depreciated and all that. But if you do not communicate with us and say, you know, the situation has changed and then this is how I want to play the game in order to rehabilitate the company, it becomes very difficult for us. But I think what is important as well is that kind of a communication, especially with the specialists that we're working with. And they will also, like you say, have to take now the matter back to the committee now to say now the matters have now changed and then this is how the outlook looks like, and then do we actually vote for? Because otherwise, to be honest with you, this time is it's got very limited timelines, but the matters that you can agree that the matters that you're dealing with, they're really being prolonged. And yes, it's not because of your doing, perhaps it's got other matters, but also we need to look at where the process is not really being abused, it's not being prolonged because you want to suck out a little bit that we have. It was quite interesting what Lizette was saying now, because we also want to have a stake. And that's why now Ashley is talking about also now having to we have to know where did the money go? Because there's $1 million question that I'll be asked when I present the matter to the committee. Where did the money go? So then the accountants and everybody will just have to look at exactly what happened, because in instances we'll find that there was money, but you decided, you do not care about us. You don't want to pay SARS and all that. So obviously we're looking at stuff like that, but we are more open to, like my colleague have said.
Thank you. Khalid, Dr. Mabasa, thank you all so much. Oh, sorry. I thought you were telling me to.
We're in agreement.
What I'm warmed by today is that SARS is giving the impression that they receptive to engagement in the business rescue process.
Yep.
And that judgment I'm not aware of, so we'll try and look for it. But is SARS saying that, all right, let me put it this way. In business rescues, I always talk about this as the tight knit between stakeholders. And if any one of the stakeholders is loose out of this finger hold, that's the end of the business rescue. So we talk to landlords as a stakeholder. We talk to employees as a stakeholder. We talk to lenders as a stakeholder, major creditors as a stakeholder. SARS has always been on the outside, and I think it's perception. I think it's that you're and us kind of thing, you're the enemy, and we'll just deal with you in whatever way we want to. And I don't think that's right. And that's why I think this session today was exceptional, because I think SARS is now, I only got 4 fingers that can fit in there, but SARS has become now that 5th very integral part. So is it that we go away from here today on the basis that SARS is saying that just like I have weekly 15-minute sessions with key stakeholders, SARS is receptive to have those engagements 15 minutes on a Zoom or a Teams platform and have those engagements? Is that what we're leaving with today? One of the takeouts of today.
We're leaving as friends today. Well, thank you. Can you all give a big hand, please? I'm going to hand back to Buhle. Thank you.
Thanks, Colin, and your panel. Before we go to Before we go to have lunch, there's a prize giving lucky draw arranged by Hollard, and Buhle has provided thank you mugs on the table, so please grab one. May I please ask a representative from Hollard to do the lucky draw? She's coming.
Okay, we have an espresso coffee machine. So I do hope that you are currently here in the building. We will not be sending it off to your office if you left. So everyone that's here that will obviously benefit from the prize. If you can go ahead, please.
Just know if I don't win, it was rigged. Hosing Kaiseng.
No.
Please don't forget to collect your mugs. And so before we have lunch, I wish to thank on behalf of SARIPA the following parties who have worked very hard to put this conference together: the SARIPA Northern Region Committee, our formidable speakers who were all excellent today, And last but not least, our sponsors, that is Hollard, Court Bonds, Brawl, Asset Auctions, Michael James Organization, and WH Auctioneers. So please join us for lunch and use this opportunity to continue networking. See you shortly and thank you for attending. Please be on the lookout for our next conference. Thank you.